Okay, so let me go ahead and call the case. This is 23 CF 475 State versus Josie Dikeman.
Matthew Torbinson and Emily Root appear for the state. Also present at state's council table is Investigative Sergeant Rich Amundsen. Good morning, Your Honor.
Morning.
Morning, Judge. Ms. Dikeman appears in person with her attorneys Chris Sacker and Dave Bowles. Also present is paralegal Emily Sanchez.
Couple issues to talk about this morning. One is the issue of the photos. The court has had an opportunity. Did you want to mark this as an exhibit, or we will at some point?
I have them printed. If I can have that marked as well, Your Honor.
Okay. The court has had an opportunity to review the exhibits. I also went back over the stipulation. One thing, there isn't a minor error in the stipulation. I don't know if you caught it. It says on the page 2, it talks about October 23rd, 2023. I think that's supposed to be, yeah. Well, also there's rescheduled to October 30th, 2102. So that's, I don't think either of those dates are right. So, just so you know, there's just some errors if you want to just correct them.
I think those are typographical. We can correct those.
Yeah, I didn't notice that until last night when I reviewed it. But the issue, and I know you made your arguments yesterday about it, so I'm going to just make a decision on these. The issue I see is that the 2011 and the issue that she gets in, that Ms. Dikeman ends up having the conviction from, is really from the 2013 situation. I think the 2011 situation is explained, and these pictures are from 2011, when HT was very young. It says 21 months old at the time. The problem I see is there's I mean, I sort of understand if there was testimony that you might show these, but in the context of the stipulation, it's sort of it doesn't, I don't know how you actually bring them in that makes sense. I also think they are I mean, they're not extreme photos in the sense that you're looking at something like we saw earlier in this trial, but they still are, bruising, et cetera, that should be able to have explanation to. And I think if they're presented, the issue I see is, well, how does one cross-examine on them if you don't have the records for them? And I think that creates another problem. So I think they're prejudicial, but also I think it has a little bit of a problem of how they get presented, and how the fact that the defense doesn't have any records from that period, which is one reason why that it's part in the stipulation that says at the very bottom, of the stipulation, which is that evidence from the 2011-2013 investigations have been destroyed pursuant to the police agency data retention policies. Evidence from 2013 was destroyed following Ms. Dikeman's conviction. The records were not destroyed until Ms. Dikeman's time to appeal for her 2013 conviction had passed. Deleted evidence includes photos, recorded interviews, police reports, and may have included facts helpful to Ms. Dikeman's defense in this case. Regarding the evidence from 2011, you may infer the evidence was deleted would have been favorable to Ms. Dikeman. Problem I see is this is evidence from 2011, and we don't have the evidence from 2011 we don't have the full evidence from 2011. So I think it creates a problem of fairness. I also think this inference gets sort of countered by the photos. So I think there's an explanation within the stipulation. Given those limitations, I'm not going to allow the state to use those photos. So that's one issue. Was there another, anything else to this morning that we needed to resolve?
Judge, one housekeeping matter. There was an exhibit that was marked after court had adjourned for the evening.
That's right.
it was a transcript for the DAR rule. I for that. Yeah, 261. We'd offer 261.
265. And that's the transcript of the clip,
Dr. Peterson's interview.
Dr. Peterson's interview, okay. Any comment on that from the state?
No, I think we presented Dr. Peterson's interview, so we have no objection to that.
It's of the phone conversation between.
Oh, okay.
Okay,
Yeah, let's.
wait, did you introduce?
We got a copy of it from them and we
Okay.
introduced it.
Okay,
Okay.
okay, that's what was confusing me. So this is the phone call from,
Mayo,
Is it
Mayo
911?
staff.
the Mayo staff phone call, okay.
Your Honor, we also do have a pending motion, the motion in limine addressing Dr. Glowacki's testimony.
Oh, that's right. Why don't you reiterate what the motion on the doctor's testimony?
Well, the motion cites a comment made in Dr. Glowacki's interview with law enforcement regarding a premonition she expressed at the time to other staff, indicating that she was concerned that if the patient returned, it would be deceased. I indicated many of the reasons why that should not be touched in any way on her examination. Certainly, it's essentially expert testimony, essentially, that she formed this impression that this occurred and was likely to produce death. And she's not a noticed expert. She's not qualified to make that assessment in any way. And that assessment is not based on her clinical observations. This was a femur injury. So this wasn't anything other than essentially propensity and expert testimony that has not been noticed and is outside the scope of her role in this case. She's a fact witness, essentially.
Yeah, and now I'm remembering which one it is. There may have been a number of motions eliminated in this case, but what's the state's response to that?
This is really easy. I don't plan to go into it.
Okay. All right. Yeah, if you could just inform her to avoid that.
Yeah.
statement.
If I can go out and talk to her before, just to make sure that she knows and is aware of that, I would appreciate that, Your Honor.
Yeah, and I'll give you an opportunity to go talk to her about that. One other issue, I would ask the defense, if you're intending to call Ted Colkine, need to know the date. There's a bit of a conflict with court personnel that we need to have a different person be here.
Sure. Wednesday or Thursday would be my guess.
All right, if you can let us know by Monday, what day? Because the issue is that we have to get somebody to be available on that day. So we don't want there to be any inference of anything. Because of
I understand that. And I understand the rationale here.
Okay. And if you need further explanation from the state, let me know and I can explain that.
I don't.
Okay, anything further from the state?
Just procedurally with our second witness, Ms. Root is going to be handling the second witness that we're going to present today. She has requested that she not have to use the podium, but question from the table because of the number of exhibits we're going to have. I think it's going to speed things along and help the procedure if that takes place.
Yeah, I have no problem with that. Just make sure the microphone's pointing at you, that's all.
Absolutely, Judge. Thank you.
Yeah.
And then I'm planning on asking that the other act stipulation be read to the jury after the first witness. I know that the court has the limiting instruction that the court plans to also present. My only request is that the limiting instruction states identity, but I think the court's original ruling was identity and method of operation. So I'd ask that method of operation also be added to the purposes for which the jury can consider the other act's evidence.
Yeah, I started going back through this. It's the conflict between identity and method of operation being somewhat similar. And so if you want me to say method of operation, I would include it in the same definition as identity. Does that make sense?
I would just ask that after you put identity, you say and method of operation.
Okay.
Because I like to use method of operation when I discuss other acts evidence. That would be my only request, Your Honor.
Judge, just so it's clear, method of operation is a route of proving identity. Just so it's clear in the stipulation that it's just one way of proving identity, not something completely separate.
Right, and that's why when people say, when they bring motions for other acts and say identity and modus operandi, it always gets very confusing because really modus operandi is a way to get to identity.
My main concern is the jury's going to be given that instruction. If I refer to it as method of operation in my closing argument and they say, well, I can only consider this for identity, I don't want it to be confusing to them. So I will elaborate, I will explain it during my closing. It's just phrasing that I prefer, and I'm just asking that it be included.
But it is constrained to proving identity.
Okay, I'll tell you what, I'm just gonna leave it as is. I'm sorry about that. If you could explain it during your at some point during your closing. The reason is it's not even in the standard jury instructions in 275 about how to put that in here. If we're talking about it, in 275, they talk about identity. They give a definition for identity. I think that's what I used in the end. So I'm just going to stick to 275.
I understand the court's ruling. In my brief and in the case law I provided, it explicitly talks about method of operation, and the court ruled that that language was okay or one of the methods. And so just for the record, that's why I'm asking for it.
Yeah, I understand. It's just that the standard jury instruction doesn't have that caveat in it, and so I'm sticking to what the jury instruction committee has suggested as the right instruction. And I've only added a little bit that the defense added on the issue of propensity-free reasoning. That's the only thing I've added, really.
I'm really just asking for 3 words to be added for the state.
I know, but I don't know how to say that without stumbling over it. And then there's a question of would I put identity or method of operation or and method of operation? And then the question would be, well, what's the definition of method of operation? I think it creates confusion, to be honest.
Would the court consider putting identity, i.e. method of operation, which it just explains that method of operation is a form of proving identity?
So this is what it says. Definition. The evidence received in this on the issue of identity is the prior conduct of the defendant so similar to the offense charged that it tends to identify the defendant as the one who had committed the offense charged. It doesn't use the term method of operation, but it's essentially that definition. So I'm going to just use this. And that's, you want me to read, I was going to read that after you talk about the other acts.
Do you want me to read the stipulation into the record, or does the court want to read it?
I can read it. It's, I do need the new dates then. Is that October? I assume October 23rd, 23rd. I'm not sure what date that is. 2013?
I believe that would be accurate, 2013.
Yes, and I would stipulate. It was a long stipulation. Oh, 20. Yeah, I'm told. Yeah, it'd be 2012. Is our understanding.
Yeah, it would make. Okay, that would make sense. October 23rd, 2012 to October 30th, 2012. That would make sense because of, even though it says 2102, but that would be just an inverse of 2 letters, or 2 numbers. Okay, wait, I'll tell you what. I'll read it, do my best. It's a long one. If I miss, I'll do it, and then we'll do something I stumbled over. We'll take a break at some point, and then I might have to repeat it if it's a horrible stumble. And I'm just saying that up front because it is relatively wordy here, and I don't want to misstate something. So I'll be very careful and read it out loud. So
because it's so long, would the court consider giving each jury member a copy of it to read along with? It is stipulated facts. And then they could be collected immediately after.
You know what? I think that's appropriate. Any objection to that?
No, I think that's consistent with the rules of evidence. So.
I think that's appropriate. Why don't we do that? So we need a clean copy.
Yeah, was there a second date where I transposed a number? I think the court indicated 2.
Yeah, it's in the same line, though.
Okay. Okay.
It's in the same line. It's that second dashed line in right after doctor appointments.
Sure.
Yeah.
In my defense, I think we went through at least a dozen revisions between the two of us. So.
Attorney Zachar is 100% correct. We worked diligently on that.
Yeah. No, I appreciate it. I appreciate it. This is not an easy stipulation. I didn't find anything else other than that.
Yeah, I consent to the court correcting as indicated, or we can certainly pull it up and.
The only thing is, if we're going to hand it to him, I need a corrected copy so we can print it off and do that. So we have a little time today. Hopefully by maybe over noon or somebody can correct it and print it off.
We were hoping to do it after the doctor testifies,
Oh.
but maybe we can take a break after her testimony and resolve the issue.
Okay. Or if either one of you want to correct it and send it to Christina and she can print it out.
I'll see if Ms. Sanchez can pull that up and we can send it out to everyone.
And actually, would you do me a favor and also send it to me?
Sure.
And the reason is I might put it in bigger format, so when I'm reading it, it's, I don't know if you've all caught this, but I have a little bit of dyslexia, and so I need to be able to follow it a little bit closer than most other people.
Sure.
Especially if it's stuff I don't usually read. So that's why I say these things. So having said that, anything else we need to talk about then?
No.
No, Your Honor, I know the state needs a minute to talk to Dr. Glowacki here, so.
Right. Why don't you go talk to, once you come in, we'll bring the jury in.
Okay.
Oh, wait, there's one more issue, Mr. Torbenson. I forgot about this issue.
Do you want me to explain it to them?
No, why don't I explain it?
Okay. No, the blonde lady. Forward, I think it's. Okay. Yeah.
Yeah, okay, all right. Forgot about this issue, and I'm glad you came in, Kevin, told me about this. One of the jurors, after Ms. Ford testified, realized that that juror worked with Ms. Ford's husband. I think it was a different last name that was presented, so I'm not surprised they didn't know it. We could bring that juror in and do a voir dire if there was a concern about their how they are on the jury, or we can, if there's no concern, we can proceed. Obviously, this person, I don't know what the relationship, but probably is more appropriate to do some type of questioning just to make sure we understand. Or I could ask, no, I think that's probably the best way. I've done it that way in the past, unless the state has different feelings about that.
The only thing I was thinking, Your Honor, is that if she disclosed it to someone, I think that's out of an abundance of caution. And I think if it could be communicated back to her by someone directly from the court staff saying, does that affect your ability to be fair and impartial? And if she responded no to that individual and made a record of it, I think that would be sufficient for me without drawing enough attention to it.
Would there be, could I do that? What I would do it is I'd walk out in the hallway and have that person pulled out, just say, ask them, can they be fair and impartial, come back and report. But I'd have to have permission from both parties.
I would trust Your Honor to do that.
And I guess I would ask, was it communicated that you would struggle to be fair and impartial as part of this, or was it just a disclosure of, I realized.
Yeah, but did you just, they just said, they just wanted you to know it was the relationship, right? Yeah. They didn't say anything about it.
Judge, I trust the court if the court wants to have a chat with the juror and just see what her views are after that.
Yeah, I actually don't even know if it's a her or him, to be honest.
My apologies.
Yeah. So why don't I do that while you go talk to the doctor, and then I'll come back in and I'll let you know.
Okay, thank you.
Thank you.
Talk to juror number 2201. That's the person. JH. At work, different department, they cross paths every once in a while. Outside of that, they don't have any social. He said he could be fair and impartial. That was basically the conversation. Other than the fact I don't know anybody's name. So I had to figure that out. But anything else? Is there any concern about that?
None.
Any concern?
No, I trust the court's assessment, and if the court believes that the juror is still fit to serve, then I would agree.
Yeah, I think he's fit to serve. He said he doesn't even know them. He realized it just at the moment she said her name, what it was, who she was. So, okay, having said that, have you talked to the doctor?
I have.
Okay, let's bring the jury in, and then we'll bring your witness in.